All right, welcome to the Great Trials Podcast. This is Steve Lowry with Yvonne Godfrey. Yvonne, how are you doing with your new garden?
I'm good. I
Did,
can't.
did, did we explain this on the last show? What you're doing as far as your gardening?
No, I think we talked about it before we started recording, but I got an indoor hydroponic garden thing for in my kitchen to grow vegetables and stuff. Even though, are you thinking it's the summer? You could grow vegetables outside.
Right,
Yes, you
right.
could. But I was like, no, I'll get a very loud, very bright hydroponic garden and put it right where I typically work. So
I,
it's thrown me
I,
off.
I was actually, so I was expecting to see like just, like massive, bushes or, stuff. And I guess I didn't think about the fact that your plants are still very, very small. They're on their way.
It's been 1 week. It's been
Yeah.
1 week and nothing's dead yet. So
Right.
if we ever start putting our podcast on YouTube, I'll offer some visual updates for the listeners, for the
Very
gardening
cool.
fans.
Very good. Very good. Well, I want to go ahead and welcome our great guest this week. We are pleased to have Tyler S. Thompson as our guest this week. Tyler is a partner at Dolt, Thompson, Shepard, and Conway PSC in Louisville, Kentucky, and you can look him up at kytrial.com. Tyler, how are you doing?
Doing well, thank you.
We were glad to hear that you were, well, I mean, not glad for you, I assume, but you were supposed to be on trial this week, but it looks like you got continued, and so you got a little bit of time to talk to us while you're on a short break.
Yes, we had a trial starting in Wilmington, North Carolina, a med mal trial, and unfortunately, COVID is kicked up there, and the trial was continued until 2023. So,
oh my goodness,
yeah.
That's not a short continuance. I mean, that is they've really pushed that thing back.
Yeah, that's how backed up the courts are right now with some of these COVID issues and the backlog of criminal trials that are.
Yeah, it's definitely hard to get things to trial right now, but I know everybody's doing the best they can to push them. Well, Tyler, let me tell everybody a little bit about you, more than what I've already told them about you. But Tyler is a graduate of Berea College in Lexington, Kentucky, I think. And
Berea, Kentucky.
Berea, Kentucky. Okay, I messed that up. And then went to the University of Louisville, Brandeis School of Law, and has been practicing law for a number of years, had just some fantastic results, great trials. Not only is Tyler an AV rated lawyer, he is a member of the Inner Circle of Advocates, has been named a number of times as a top 50 lawyer in Kentucky by Super Lawyers, a top 10 lawyer in Kentucky by Super Lawyers, and then in 2021, this year, he's been named the #1 lawyer in Kentucky. So that's a great honor, and we're glad to have Tyler on. He's also a friend of our firms and the shows. He won the Pete Perlman Outstanding Trial Lawyer Award. Pete's a fantastic lawyer from up in Kentucky, and Tyler has 3 daughters and is on the board of the Kentucky Association of Justice, as well as, I thought this was cool, the board of the American Museum of Fly Fishing. So I thought that was pretty cool. So you must be an avid fly fisher.
I am. That's one of those boards that you really don't mind serving on. You find a lot of good places to fish. So.
That's right. Exactly. Well, thank you so much for coming on, Tyler. We really appreciate it. This case that we're talking about, as I was reading it, it's just one of those things that as a parent, it scares you to death, and you never want to hear about. But the name of the case is Lowry Rone, on behalf of Shannon Houchin versus Republic Services of Kentucky, doing business as Monarch Environmental, garbage trucks, and Jackie Jones. This case was tried in Warren Circuit Court, that's in Warren County, Kentucky, back in December of 2002. And resulted in a total verdict on behalf of Shannon of $27,335,667.87. And Shannon was a 17-year-old senior in high school Just by all accounts from her friends and teachers, just a tremendous young lady, very active, loved pets, aspired to be a daycare owner, loved children. Just pretty much everyone loved her. She worked a part-time job at McDonald's in Bowling Green, Kentucky. And on November 23rd, so Thanksgiving morning, she had spent the night at a friend's house after having dinner with some of her co-employees, like a sort of early Thanksgiving dinner. She left her friend's house and was going to McDonald's. She was going to start working the 9 a.m. shift. She left an hour early and was going to be about a half an hour early. So she wouldn't, we know she wasn't in a hurry. She was driving on a 2-lane road, and I do have the name of the road written down here somewhere, but driving on a 2-lane road, crested a hill, and a garbage truck was parked facing the wrong direction in her lane of travel. She tried to steer to the left, and unfortunately, at least this was a highly disputed point, but from the plaintiff's perspective, there was one of the garbage men, I think he's called the tipper, somebody who works the controls that compacts the garbage, was standing in to the left of the garbage truck, so caused her to steer back to try and avoid him and end up sliding sideways into the truck in her 1987 Honda Prelude. And from what I understand, the injuries didn't look that bad initially, except that her head injury was catastrophic, and she suffered one of the worst brain injuries that we've seen. And we're going to talk about this during the show. The amount of ways this affected her, not being able to control her eyes, being incontinent, having dementia, having this. I think it's called hyperphagia, where she doesn't realize that she's just eaten and so eats again. So she went from being a very petite young woman and gained about 60 pounds within a few weeks after coming out of 57 days of coma. So just a catastrophic brain injury. And surprisingly to me, I guess, is how hard the garbage truck company fought this case. And even though they're sitting facing the wrong way on the wrong side of the road, basically just was unwilling to take responsibility for doing that, even though, as you pointed out over and over in your opening and closing, that their own policies and procedures and their own manager had told them time and time again, don't park on the wrong side of the road. And that's exactly what they had done.
Yes.
Yes.
Part of the defense of the case really had to do with conspicuity and how visible was the truck, at what point was it visible, how much distance did she have to stop, at what speed. And so, a day or two after the accident, they had a accident reconstructionist from Nashville out at the scene, coming up with a defense. They argued that Shannon was traveling too fast for the conditions of the road. Interestingly, the road wasn't marked. It's a country, little 2-lane country road. It's not particularly wide. And the defense is that even though it's not marked by statute in Kentucky, it's a 55-mile-an-hour speed limit. But they said, well, she shouldn't have been traveling that speed. And there was a difference. I think our expert had her going about 46 miles an hour when she came over the hill, based upon, the crush analysis of the vehicle and the yaw marks and where they were. Their expert had her going 55 miles an hour. So neither one had her going over the speed limit, but
Right.
But their argument was really fairly simple, and that is, you could see the top of the truck from 275 feet and going, 40 or 45 miles an hour, or 50, even a reasonable speed. She should have been able to stop about 70 feet before the truck. Of course, that doesn't take into account an enormous number of factors that she would have had to deal with that morning. that our experts talked about.
Right, right. Yeah, you know, it's interesting. It made me think. I just had a case that was actually set to go to trial in a couple of months, where a cotton planter, a tractor and a cotton planter were driving on the wrong side of the road, and they claimed that the tractor was sitting there stationary. We claimed he was in the middle of a turn and swinging out into our client's lane. Anyways, it clipped our client and ended up severing his arm. And so we got into a big, that was a big part of the case, was conspicuity, perception reaction, which you went into a lot in this case, you know, braking distances and all that kind of stuff. You know, so you know, one of the things that I thought was very interesting is even at 275 feet, and I know, I think the evidence, even the defense was saying that once she crested the hill, it was somewhere more around 150 feet. But you know, that sounds like a lot, but when you're going 45, 50 miles an hour, I mean, you travel, I think you pointed out at 45 miles an hour, you're going 70 feet a second. So you're essentially have 2 seconds if it's 150 feet. So it happens very quickly. And, you know, when you get into this idea of how long does it take somebody to perceive and then react to that, and then, you know, if they hit their brakes, then you got the braking time as well that would be added into that.
Right. You know, we hired an expert out of Iowa who runs the world's largest computer simulation machine that Ford Motor Company, GM, all these companies use. We've remained friends. He's now active in this, you know, driverless vehicle trials and studies they're doing. But anyway, he came in and testified in this case. And one of the things he brought up that you know, I'd really never thought about until he brought it up was the rule of expectancy. And he says, you know, if you come up to a red light, and it turns green, or it's green turning red, you expect that, you're attuned to it, you react much quicker. There's no indecision. And then if you have a situation where, you know, a truck is facing you on the wrong side of the road, all these thoughts start going through. What's it doing? Is it moving? Can I go right? Can I go left? And he said in the computer simulations that they used to do, they would do these trials where they would have a, you know, like something jump out in the road to see how people would react on computer simulation.
Right.
And they called it the wagging foot of indecision. And he said you could see the foot of the person go to brake, back to gas, to brake, back to gas, just kind of hovering back and forth, trying to decide what to do. So they even came up with a name for it, you know, the wagging foot of indecision. So, you know, my argument, you know, in this case was, well, you know, generally they'll agree upon 1.5 seconds perception reaction time. She reacted very quickly. You know, they tried to argue that because she had been on some ADHD medicine that she was inattentive and wasn't paying attention. But she actually reacted and moved over to the left in about 0.7 seconds. So the real issue was, well, why didn't she brake? Why did she, you know, go around the truck? And our argument was, well, she had so many variables and factors to try to consider that, you know, she was over in the left lane. She was going to go around the truck. And then what I believe clearly happened is the tipper, who's on the back of the truck, then had to walk out, since they're parked, you know, in her lane of traffic. And normally they're supposed to be over on the other side of the road. So they have all the machinery and the handles on that side of the truck. So they're on the right side of the road. The handles are on the right side of the truck. He's standing off the road. He's not in any danger. When they pull across and park on the opposite lane on a 2-lane road, then for him to operate the levers, he has to walk out into the other lane of traffic, which is what I think happened. He was either walked out or he was standing there, because he testified, when I looked up, she was already into the yaw. And of course the truck's real loud, so I don't think he heard her. Right. And she's over there, she sees him, he's not looking. She gets in that lane and he either walks out or is standing there, and she cut the wheel back to her right, probably going to try to go in front of the truck to the right, but unfortunately slid into the truck sideways.
And one of the difficult things for you was that your client couldn't remember the incident at all, right?
Right. Yeah, she unfortunately was in a coma for 48 days, I believe, or 52 days, and had no memory of the accident whatsoever, and really had no short-term memory. She did not testify at trial. I made a conscious decision not to bring her into courtroom. She did not even sit through the trial. Her mother was her guardian, and that worked out well. It's a great family, unbelievable. That mother, interestingly enough, the mother was an EMS driver, and I can't remember if she was off that day or had switched with somebody for some reason and was not working, or she would have been the one to go to her daughter's wreck.
Wow.
Oh, wow.
One of the things it really stuck out to me in reading your opening about the law of expectancy, because I had not really heard that either in terms of reaction time. And it made perfect sense to me. Like if you think about when you're driving, and occasionally you'll see when like an 18-wheeler tractor is like towing another one and it's facing backwards, like it's facing you. Yeah. And how there's just a second that looks so weird because, it looks like something's in your lane of traffic coming towards you. And so just from a common sense perspective, I could absolutely see coming over a hill and maybe you're expecting taillights or the rear of a vehicle, but to see a vehicle facing you, how that would absolutely play a part in just, fractions of a second, which in that sort of at that speed make a difference. Why you'd have that. I mean, I have personal experience with that wagging foot of indecision. So
right.
I completely get that. But I thought it was very effective the way you explained that to the jury and led with that fairly early on, because, that was one of the things I think reading the defense. And as Steve pointed out, the way it was defended, I think it was very frustrating to think about how much defending you had to do of Shannon's reaction time because somebody else was in her lane of travel facing the wrong way. I mean,
right.
It's just hard to stomach.
Yeah. And then, we went out and canvassed, of course, the scene, and we had an accident reconstruction come in and, get all the GPS coordinates. They do a total station and map out every aspect of it. And there were a number of other variables. There were mailboxes on the side of the road. There were trees. There was a kind of a berm or with a large ditch, that sort of dictated, okay, I can't go right. I'm going to go over to the left and just go around this truck. And then we had to find witnesses to kind of, explain all that. One of the things that I like to do is, if I'm teaching seminars to lawyers, I'll say, think about the case you want to present to the jury and then go make that happen.
Right.
So if you want to tell the jury, hey, they knew this was wrong or they'd been warned about this. Okay, I'd like to tell the jury they'd been warned not to do this. How do we do that? So we actually, drove out in the country and parked and just walked to every house kind of down that road near that area and said, if we represent this little girl that was devastatingly injured in this wreck. And, if you all had any experience of coming over the hill, well, we found 2 or 3 people that had. One lady that lived right there said she had gone out on 3 different occasions, had called them and told them to quit parking on the other side of the road. The last time was about 2 weeks before the wreck. It had been like a year earlier, 6 months earlier. And both times they assured her that they would talk to them, make sure they didn't do it anymore. And then I think 2 weeks before the wreck, she said she was out there and a car had to slam on its brakes and it kind of swerved over toward her yard. And, she said, this is so unsafe. And she called them again. And then we had 2 witnesses who had driven that road every morning and to go to work and had incidences. One who said she slammed on her brakes and stopped about 5 feet short and she was shaking. She was so scared that she almost hit the truck. Another one said, I would have hit the truck, but I went around it to the left. I don't think I could have stopped in time. Both of whom called them and said, you all need to quit doing this. So my great frustration in the case is that the judge, who was a very fine judge, but he did not give us a punitive damage instruction, which I, really was frustrated with that. But it gave us a great argument on appeal when they, filed their appeal. We cross appealed on the punitive damage and said, guys, we're going to come back and get twice as much. So
I was wondering about that because it seemed to me with the amount of evidence that you had of people who had called in and complained about it, that would be a pretty good punitive damages case. So the judge just didn't go your way on that?
Yeah, punitives in Kentucky can be a little tough to get. But he said that, with an employer, you got to show they ratified it or condoned it. And we actually had some of that, I thought, with some of the proof. We did have another witness who about, I don't know, a year earlier, he was actually the mayor of a little small town outside of this little town of Bowling Green. And he said he came around a curve. This garbage truck was parked in the middle of the road. He blew the horn, and he said the guy made an obscene gesture at him as he went by. So he called when he got to work, he was so upset. He called and said, look, I blew my horn to tell him this was not safe. And, the guy, flips me off basically. And so he says, I wasn't happy about that. And he said, I called and spoke to the supervisor, and he said, the guy just wouldn't listen. He was kind of a little bit obnoxious about it and said, well, buddy, they can't pick up garbage moving. They got to stop. And he said, well, I know they have to stop. They don't have to stop in the middle of the road around a curve. And he said, well, the law says they can stop where they want. And he said, well, okay, I hear you, buddy, but let me tell you what I'm going to do. When you all have a wreck and cause somebody to be injured or killed because of what you're doing, I'm going to call their lawyer and make sure they know that I had this conversation with you. So I get this phone call from this guy. He tells me the story and says, I told him I was going to do it. I want you to know I told him a year ago to quit parking, in dangerous places. So I thought we had some pretty good evidence of punitives. But
yeah, I mean, it was great evidence and extremely effective. And you made the theme you were able to put on because they wanted to blame Shannon so much for what happened. And the theme that you were able to build out of that is, this company, Republic Services, has had 2-3 years to know about this and about parking on the wrong side of the road. And, Shannon had 3 to 4 seconds. So if we're comparing, who had more time to take action and do something the right way, it's obviously Republic Services, which I thought was just really effective. But I wanted to go back to 1 second about you finding these witnesses, because it's just such an important point for, people who want to work up cases and try them, is to just get out there and meet with witnesses and spend some time out there at the scene. One thing I'm wondering is how long after the incident did you have people out there, talking to locals and witnesses?
I can't remember exactly when we got that information. Shannon, we actually got the case pretty quickly. I think within a few weeks, they had retained a lawyer, and it was a lawyer in Bowling Green who then called me and said, hey, these are friends, it's a family, and I'm trying to get them a lawyer, and, would you do this? And so I got in early, which is unusual. A lot of times, we do a lot of medical negligence work, and most people think they're going to get better. And, sometimes 6 months or a year goes by before they call a lawyer. This was relatively quickly, within a week or two, because, they had this family friend who was an attorney. So I think we got out there fairly quickly. I mean, it was within probably 30 days that we were out there talking to people, trying to see what they saw, what they remembered.
Yeah. Well, I noticed that it looks like you tried the case just about 2 years after the collision.
Yes.
So
we pushed it hard,
Yeah.
Most people who aren't lawyers would have a hard time understanding how long it takes to get these cases to trial, especially when you've got that many witnesses. We had because of the circumstances of the case and what our focus groups showed us, we ended up actually calling a lot of witnesses because we felt like we needed to. But it's not unusual to take 3, 4, 5 years for a case to get to trial.
Oh yeah.
We we actually had this one set even earlier. I had it set at about 14 months and it got continued. And then I really pushed it hard.
Yeah, I mean, it's very tough to do and really amazing and important, especially in a case like this where you do have somebody who's so impaired that is money that they can use towards the things that they need. And the longer they go without it, the more that's hurting them. But I kind of couldn't believe my eyes when I saw 2 years from the incident, not from being hired, not from filing, from the incident to trial is pretty amazing.
Yeah. Sorry, you mentioned focus groups, and you said that one of the reasons why you called as many witnesses you did is because of the focus groups. What were you learning in the focus groups was this more to sort of protect Shannon's actions and show that she had done, everything she could and she wasn't at fault? Or was it something else?
Well, we did 3 focus groups in the case, sort of mock trials, really. And it was kind of fascinating. The first one, we just went down and we presented the facts sort of in a mock trial format. It seemed like we had about 20 jurors or people, mock jurors, sit in on the case. And the jury came back. There were 3 or 4 of them that found her 100% at fault. And the ones that didn't find her 100% at fault found her 50% at fault. And there were 3 or 4 that said the trucking company was 100% at fault. But, the vast majority had her at 50% at fault, which I was stunned with. And what we learned was that she's a teenage driver, and, people come into these trials with their own script and, their own life experiences, and people's life experiences that teenage drivers are poor drivers. Mm-hmm. So they immediately think, oh, she must have done something wrong because that's the script. And in this case, they started, without presenting any evidence of it whatsoever, they said stuff like, well, she was probably late for work. I bet she was hurrying, she probably stayed up too late and was tired. You know how teenagers are. I bet her car was poorly maintained. Kids don't take care of their car. They had a number of these. There were like 5 or 6 things they brought up about teenage drivers. She's probably fooling with the radio. You know how kids listen to the radio and don't pay attention. It was a little bit stunning, but that was the script they had, and it was sort of confirmation bias. Now let's find a reason to sort of do what we believe. So the way we got around that is we went and talked to all of these people, and we brought in all of these witnesses. So like her boss at work, the accident happened at 8:15. She was supposed to be at work at 9. From the distance of where the accident happened to where she lived, the boss came in and said, no, she was going to be 15 or 20 minutes early to work. She had no reason to be hurrying. The mother of the teenager she spent the night with came in and said, you know what? We watched a movie and they were in bed by 11 o'clock. Nobody stayed up late. It wasn't anything like that going on. The father came in and said, I maintain the vehicle, and he worked, in a plant and was a very good mechanic. And he said, no, I made sure, because as parents, we worry about that. Her brakes were perfect. There was air in the tires, no mechanical maintenance issues. There were 3 or 4 others. We brought in, somebody said, I bet she wasn't wearing a seatbelt. So we brought in the trooper to say, no, I actually cut the seatbelt off of her. The tow truck driver said, I found the vehicle in 4th gear. It wasn't in 5th gear. And I remember the brakes worked good when I was moving the car, just various things like that to sort of combat that natural tendency that people have to blame teenagers if they're in a wreck.
Yeah. You could really tell from your opening that you took those points to heart, because you kind of right at the beginning, pointed out that, she wasn't in a hurry. She wasn't speeding. She's wearing her seatbelt. She's a good student. She's, a responsible teenager, wasn't the person who going out and getting in trouble. I mean, just kind of hit all those points right at the very beginning. and then got into the story about this truck on the, sitting on the wrong side of the road. So I thought it was very effective, sort of taking away all those things that you could see that the defense was going to be bringing up and trying to make a point of.
Yeah. And when we focused it the second time, bringing forth all these things that, we really didn't think would be an issue, they put 100% of liability on the garbage truck company. And then the last one was on damages. We wanted to focus damages and sort of get an idea about that. But that was the most interesting aspect of the case to me, this tendency to look for a reason to blame the teenager,
Right.
even in a situation where it's pretty clear she hadn't done anything wrong. And then sort of how to handle that, which you're right. We thought, okay, let's get that out there in the front. There's no drugs or alcohol involved. Let's make sure we set the stage so that we sort of obviate that.
Yeah.
Well,
go ahead.
Well, I just was going to say that's it's so important, and something that I feel like sometimes we learn the hard way in trials, or sometimes you hopefully just learn it from a lawyer who's more experienced than you. Because I think, especially when you're starting out, even if you're thinking about focus grouping, you're thinking about focus grouping the problems in your case or the weak points of your case or the defenses that you've sort of identified based on like the facts and the documents you have. And you have to keep in mind that there's also all these conceptions that at least from sort of the lawyer brain, sort of black and white point of view aren't implicated in your case, but because of the way jurors can think are implicated in your case. But, luckily you spent the time to do that and really took away all the things that somebody might be thinking, that because she had gotten together with friends the night before was, could they have stayed up late or had alcohol or drugs, just all those things that I found as you were addressing them in your opening. Those were questions I would have had if I was on that jury, So I, as Steve pointed out, that was very effective to sort of knock that out in the beginning.
One thing I wanted to ask you, in looking at the judgment, I'm not sure this is the same way that the verdict form would have looked, but it looks like the jury had to get over a number of issues that or whether or not Shannon was at fault. So what's the law in Kentucky on comparative or contributory? We
have pure, so they could find her 100% at fault or 5% at fault or 1% at fault. That's the and it's funny because we got into this sort of semantic argument. Is for me, a trial, I always like to look at the jury instructions early on in the case and say, okay, what jury instructions is this jury going to hear? Because that's really what the case is about. Yeah. And in this case, one of the jury instructions under Kentucky's motor vehicle statute is she had a duty to keep her car under reasonable control. And that was a big part of the defense, is because everybody kind of, agreed that when she was yawing, her car was out of control. So, they came up with this sort of simplistic argument that, well, she has a duty to keep her car under control. And as she was yawing, sliding into this truck, her car wasn't under control. So she violated her duty. And, thankfully the jury saw past that.
Right.
Right. Everybody loses control of their car when they wreck. It's,
right.
Whose fault was it?
I think that's such an important point too, that especially the young lawyers, and I've said it a number of times, is that when you're looking to take a deposition or want to get admissions, is go back and read the jury instructions, because that's what you're going to have to prove to the jury at the end of the day. So make your questions, make what you're proving fit those jury instructions. And then once you get get those admissions in or get those, questions in, you can say, see, this is the jury instruction. Here's where they said it. So it's so important to always be reading the jury instructions, because that should be the framework for your case. Anyways, I wanted to ask you another question that you mentioned earlier, and we talked a lot about on the show, is you decided not to bring your client to testify, and you didn't have her in the courtroom. Did you bring her at all? Did the jury ever get to meet her?
The defense lawyer insisted we bring her for opening, for voir dire. So
Okay.
when we picked the jury, I did, Shanny's just the sweetest little girl, but she doesn't understand everything that was going on, especially back then. So we just walked to the back of the courtroom, opened the doors up. I brought her out. She stood in the back of the courtroom. The jurors, potential jurors, of the panel stood up, and they all sort of looked our way. And we stood there for about 10 seconds and then left. And that was the only time they ever saw Shannon.
Wow.
Which is another good point, or an interesting point about the case that I talk to lawyers about a lot of time, and that we have certain rules that we tend to follow, or guidelines. But, especially when practicing law, every case is different. And what you might do 99% of the time, there's always exceptions to that in cases where you wouldn't. And this was one of those cases. My client had a twin sister, and
Right.
My law partner, we had it's probably the only disagreement we ever had, and he was my senior partner, so it was a little tough. But he wanted me to put the twin sister on the stand and then put her on the stand so the jury could see the difference. And the medical proof, but he had not been to anything, any of the depots or things. The medical proof had come in so well, I just didn't feel like I needed to do that. In fact, I thought it would probably hurt the case. And her sister, who's also wonderful, but was going through a rough time back then. Their house had burned down. She was, I think she was depressed, and especially depressed over what had happened to Shannon. And then, being 16, 17 years old, it's a tough time anyway. So I just didn't think it was going to be helpful at all. And so I wouldn't do it, and I didn't do it. But, most times you would want to do that. You'd want to put the twin up and say, oh, look here, and here's here's the difference. But because the proof had come in so well, I did not call her or the twin.
So the way that you ended up proving up basically what had happened to Shannon then was through medical testimony, and then what we would call sort of before and after witnesses, friends and family that could talk about what she used to be like and things like that.
Yeah, and I didn't call many before witnesses. Her injury was so devastating that, sometimes the imagination is more powerful, and when you talk about the issues that she had, I just didn't feel like I needed to gild that lily, so to speak, or
Right.
or make it over. The other way proving it up, they had their expert witnesses, we had our expert witnesses. But one thing that was kind of interesting aspect of the case, they 2 days after this wreck had an expert come out and examine the scene. And, after all the testimony about not being there, not, you shouldn't park on the wrong side of the road from his supervisors, and, waste management manuals on trucking manuals, this expert they hired came in and said there was nothing wrong with parking on the wrong side of the road. It was perfectly safe to do that. And, she was at fault for not being able to stop in time, and should, had plenty of room to stop. What was interesting is, in looking at these pictures, I had taken the deposition of Mr. Goodnight, who was this tipper on the back of the truck. So in these photos, I could see them in some of the photos, the tipper and the driver, and they had taken them out there so that they could position the truck exactly as it was for this, accident reconstructionist expert they've hired out of Nashville to be able to show exactly where the truck was and get his measurements. And as he's photographing the truck, I can see Mr. Goodnight, who I recognize from taking his deposition, standing, about 150 feet down the road at the top of the hill. So I didn't get these photos till later, after I'd already deposed him. But I kind of had an idea of what was going on. So when we put him on the stand, I pulled these pictures out and I said, now, Mr. Goodnight, we've been provided these pictures and I noticed you're in some. And do you recall going out to the scene the day after this accident with, this expert who's going to testify later on? And he said, yeah, and I said, and I'm assuming they took you out there so you could show them exactly where the truck was parked. And he said, yes. And I said, I noticed in this picture that you're about 150 feet down the road at the top of the hill. Did Mr. Grimm ask you to go stand down there to warn traffic coming over the hill that there was a truck parked there? And he goes, yeah, that's what he did. So it was just kind of humorous because, his testimony that, oh, it's perfectly safe. It's like, yeah, but when you got out there, you sent this guy to stand at the top of the hill to warn traffic, it very much undercut his credibility, I thought. And that's one of those things we didn't know, we kind of got lucky with.
Yeah.
It's funny that you say that, because in this case that I was telling you about that we just recently resolved with the tractor, they took the tractor out and with the cotton planter and they put it in the middle of the road and to show where it had been and get some photos. And as we did the same thing, we looked in the back and we saw that they had blocked off traffic with police officers. And I said, so when you took that tractor out there and put it in the same spot, you blocked off the road from traffic coming. And I was like, well, why would you do that? And they're like, because it's safer. And I was like, you're right. It is safer, isn't it? So it's things like that are just so good. So
I was curious how something played out at trial. This goes back a little bit, but there was something that you had mentioned in your opening, and I was like, well, surely this is one of those things that the defense leading up to trial will be this, but then they won't really go too hard on this in front of a jury, which was, Shannon had a few years before the crash had some difficulties and had mentioned committing suicide, and so she had gotten treatment for that. And was doing very well leading up to the accident. And I sort of thought when you had mentioned that in your opening, I was sort of like, there's no way they're going to go too hard on that, going in on what at that point would have been a 14-year-old, just kind of struggling with feelings of confidence and whatever. But it looked like, based on the closing, that and the defense opening, that they at least sort of went there and sort of made it try to sound like your clients had hidden that information from them, and that was sort of, I wasn't really sure if they were trying to connect that to what they were saying were issues with attention. So I'm just wondering if you can speak to how that actually played out at trial, and how whether it was effective at all or whether it was more of a gift for you.
Yeah, I think that they way overplayed that. And they hired a neuropsychiatrist to come in and say, because when she was 14, she had gotten some counseling along with her sister and mother. They were going through teenage things, and mom's a great mom. Oh my God, if any woman ever deserved to be mom of the millennium, it would be this mother. She was just so unbelievable. She quit her job. She moved to Louisville with her child while she was in a coma, all through her months of rehab at various institutions. Just unbelievable. But when they asked her about this, she didn't tell them about it. And they said she had any prior mental health. She said no, because she had been told that all that was confidential, that, and she said, I did not want to label her as being, the kid that had some type of behavioral problem or mental problem. And so I was told that was confidential, that when I first took her, I was told that. And I thought, okay, great, we'll do this. So when they asked her about in her deposition under oath, she didn't tell them about it. So they kind of went at it two ways. That one, oh, mom has been dishonest, so this must be a big deal. She didn't want you to find out about it. It must be important. And two, they hired this guy to say because she was on ADHD medicine, from when she was 14, that maybe she was attentive 2 years later when she was 16, which was such a stretch. It was pretty bad. And I thought mother handled it, wonderfully. I mean, we went over it and we were just real honest with the jury about it. She said, look, I was told this would be confidential and it didn't have to come up. I didn't want her to be labeled. I'm upset that you found out about it now. And,
yeah.
So my argument was, hell, she's just being a great mom.
That's right. Yeah.
Which she was.
Yeah. Yeah. And I mean, it is a shame. It's a shame that you even really had to speak about it, because it does kind of just sort of reading from the transcript, at least as much as you had to go into it and not knowing what else came out at trial. I do think a lot of jurors could relate. I could certainly relate to that, just sort of seeming like a private thing. That you shouldn't have to talk about it in deposition, especially when it had nothing to do with what happened.
Right.
But you also, I mean, you did something that was very effective. And I'm wondering if you felt, I'm wondering how you made this decision and if it was a tough one for you to do, because one of the points that you made was talking about how, okay, in this earlier treatment when she was much younger, and she had mentioned, committing suicide because she felt like she was a burden on her mom. And one of the comparisons that you made was that after this accident, it was something that she talked about a lot. But the difference was, number one, how much she was talking about it, but also, you said something like, she has a reason to feel this way now because of the horrific things that she's going through.
Right.
And I thought that was very powerful. But it always scares me to talk about things like that, things about suicide, especially when you've got a client who is struggling with that. And so I'm just wondering how you kind of wrestled with that issue, if you talked to the clients about going there, or how you handled it.
No, she was not in the courtroom. So
right.
I'm always, I generally have when I give a closing argument, or if I'm going to have any kind of testimony that might be harmful, or cause someone some depression or a setback, I won't have them in the courtroom.
Yeah.
And of course, Shannon was not in the courtroom. And the thing about the suicide, it really was, she wrote a letter, and it was a really sweet letter about how much she loved her parents, but she didn't want to be a burden, and she knows she was a disappointment, and she was struggling with her grades, and she said, I think you all be better off without me, and I may just kill myself. Well, then she crumpled it up and threw it in the wastebasket.
Mm-hmm.
And so she never even gave it to him. But mom, being the mom, concerned about her daughter, found it, saw that, and looked at it and said, okay, scared her to death. And she said, we're going to get some help. And so, all three of them, went and got some counseling. But the fact she didn't bring it up, they were trying to sort of, I guess, get a jury mad at mom, make it look like she was dishonest.
Right.
Clearly wasn't. She was wonderful.
Yeah.
The other thing they made a big point out of was that mom and dad had let her go into the garage and smoke cigarettes, and she had done that a few times, and they tried to make a really big deal out of that, and I thought it was incredibly powerful. His mom, she said, pointed out all the things that her daughter couldn't do, all the things she'd been deprived of, all the things that she was never going to be able to do. And she said, she's lost so much, and the one thing that gives her some pleasure and make her feel like she can do something on her own is to go into the garage and be able to light her own cigarette. And she said, I wish she wasn't doing it, but I'm not going to take that away from her because it's the only thing she has. And it was really powerful. And it took a negative and turned it into a positive, actually. I mean,
Yeah. And we've alluded to it and Steve talked about it at the beginning, but a lot of the, I think anybody who does this kind of work, catastrophic injury, patients, you're used to certain aspects of her injury, or at least you've heard of them before, but there were some of these that were new to me, especially that I think you did a very good job of explaining in the opening. There was, as Steve mentioned, there was just the fact that, especially in the beginning, she would have to physically open her eyes and hold her eyes, tape her eyes open. But one of the things I thought was really powerful that you talked about, that I think you could make the mistake of thinking it wasn't as big of a deal as some of the other impairments, was that hyperphagia, was that issue where she couldn't remember what she'd eaten and she wasn't really getting those signals about being full. And so she'd be constantly eating or ready to eat again, not realizing she had recently eaten. And it would cause all this strife in the family because they would try to take food away from her and she wouldn't realize that she had just eaten. And that I had never heard of that before, but it sounds really scary.
Yeah.
Right. Yeah. They're both of those issues with the eyes and the hyperphagia. And she could not remember she had eaten, and she didn't feel, satiated or like she had eaten. Oh, sorry. So what they would do is, feed her, and then 5 minutes later she was hungry again because she didn't remember she had eaten, and she thought they were trying to starve her to death. And I mean, it was very, very traumatizing to the parents, to have them feel that way. And with the eyes, I think both fourth cranial nerves were knocked out. And so she ended up eventually having surgery, and they did some muscle transfers and some things to where she could actually blink. But the problem was, once they did that, her eyes wouldn't close all the way. So at night she had to wear goggles and put ointment and cream in her eyes. Devastating injury. She had severe problems with dry eyes. And then she also had disinhibition syndrome, where she didn't realize, it's like the filter's gone on when to put the brakes on and stop, what you're saying or doing. So it was, for the parents, it was just unbelievable. And, people just can't imagine what goes on when somebody is in a coma for, 52 days. And we had one really interesting, my wife's an anesthesiologist. And so the daughter was in Louisville, in a facility for people, in brain injury rehab. This is after she woke up after 52 days. She was staying up here, and the facility she was at was really bad, and mom got her moved to a better facility with a lot of lobbying, a lot of work. Well, then they came in this place one night, and a young resident who wasn't being supervisor gave her the wrong medication.
Oh no.
I was sitting at home. I got a phone call about 11 o'clock at night, and mom said, she was frantic. She said they'd given her this medication, and I asked my wife about it, and she said they need to call an ambulance immediately. She's going to stop breathing in about 2 or 3 minutes, 5 minutes. And sure enough, on the way to the hospital, she coded, and they had to do CPR, administer Narcan to reverse it. But it was just a harrowing experience for mom. I mean, she was just so traumatized after going through everything she had been through, for the last 3 months, and then to have that happen. So she never left her side again. She was there that night. She actually never left her side, but she was even more hypervigilant after that. which I always tell everybody, if you have a loved one in the hospital, make sure somebody's there 24 hours. Because
Right.
you need to double check everything.
No, absolutely. So one of the parts of the injuries she suffered, I mean, we mentioned that she had dementia, but you also described that basically her brain was shrinking, and that she had I think even from after the incident, her IQ had actually diminished even more over time. That was just a function of the brain injury, or what was happening to her brain?
Yeah, I think that was just atrophy from the damage itself. But we had a neuropsychologist, a neuropsychiatrist from North Carolina testify about that, and a great expert. It's so important to find good experts in these cases. And he was the doctor's doctor. He's the guy that went all over the country lecturing to other people how to take care of brain injured people. So he had a lot of credibility, and he said, here's what we see with this, and it's early dementia, and it's not going to stay static. It's going to get worse, and explained all the reasons why.
Yeah, and we haven't really gone through every single, I mean, because this brain injury affected her just in so many different ways. I mean, it was loss of her executive functioning. She was able to walk, but as you described, it was more of a waddle. She couldn't run anymore, couldn't ride a bike, couldn't swim, couldn't do, the type of exercise and fun things that she liked to do before. And really just affected every aspect of her life. Tyler, if you could talk a little bit about how you went about presenting damages to the jury. I mean, other than the injuries, but how you quantified that for the jury so that they could figure out what kind of value to put on it.
Well, the damages were past medical expense, which I can't even remember what they were now. I want to say about $490,000, maybe something like that. And then her lost wages from her job in the past, we just took the McDonald's wage, we didn't want to overreach.
Right.
And although she could have, maybe done other jobs, but we just took that, what she was working, and that was not a whole lot, maybe $10,000 or $11,000. And then the big number was the life care plan, which to take care of her the rest of her life. We hired a life care planner to do an analysis. That was about 14 million and something. And then pain and suffering. And, she had, I want to say 60.6 years of life remaining by statistics, that in Kentucky, we have some life expectancy tables that the courts have adopted. So that's what most people use, although you can use federal statistics. And so quantifying what that is. So one of the things is we used a big chart. I like to use rhetorical questions, and so I had a big chart, and the rhetorical question was, what happens when the money runs out?
Right.
So how you going to what's this family going to do? She needs the entire amount. She may only live 30 or 40 years. She may live 80 years, but on average, she's going to live 60.6. So, if you go with that number, she's going to need this money to care for her for the next 60.6 years. And then one of the things I like to point out is she doesn't get that. That's not going to her. That money for that life care plan goes back to the hospitals and the doctors, and it's going to go back to them over time for the next 60.6 years. If everything works out as the life care plan says, it's for medical care, it's for supplies, it's for, video cameras so the parents can watch her and keep an eye on her so she doesn't get up in the middle of the night and leave. It's all the things, that she's going to need, aquatherapy and everything else. But that goes back to the medical community. She doesn't get to keep that. So what she gets to keep is what you award for pain and suffering. And then I think they gave us about 13 million for that.
Right. One thing I did want to ask you about the life care plan, and I just noticed this in your closing, is there was some doctor in there that the defense made a big point of putting in the life care plan, and you in your closing admitted that it was a mistake. And I was just wondering, first of all, what that was. And then I always think it's best just to be honest and straightforward with the jury. So if you made a mistake, it's a mistake. that's what it was.
Yeah, there was somebody that was listed that she had seen in the past, and our life care planner thought it was for some counseling, but it turned out that he was a different type of doctor and was not going to be doing counseling. And so, yeah, we just owned up to it and said, hey, look, that's a mistake. Leave it out. You should. That's the right thing to do. They're right about that. And yeah, sometimes you just got to be straightforward. And
yeah. So, one thing that we hadn't asked is, so this was in Warren County. My understanding is that's a fairly small county. What kind of venue is that? And then the second part of that question is, did you get a chance to talk to the jury afterwards?
Yeah. So a couple of interesting things. Warren County is not a really small town. It's a rural county, but it's where Western Kentucky University is. So they have a pretty good population and a fairly sophisticated population. And, Kentucky's not known for necessarily giving out large verdicts. It's especially out, if you get outside of Louisville, Kentucky, it's more rural and much more conservative. And I think they were sort of kind of betting on that a little bit as part of the trial. But I did talk to the jurors afterwards. And one of the jurors said, yeah, we got back there and we thought she deserved all of it, because I think I was asking for about $33 million maybe. But he said, we really thought if we give the whole thing that, on appeal, they may think we just rubber stamped something and didn't pay attention. So we knocked some of it off. That's what he told me.
Wow. Wow.
Well, that's really good. And one other thing I wanted to ask you about their defense of the case, which was this idea that they were trying to paint themselves as a public service vehicle, and almost that because they're a public service vehicle that they can do what they want. How did they play that, and how did that go over at trial?
I don't remember a whole lot about that issue, other than that there was a statute that sort of exempted public service vehicles from the duties of a regular motorist, in that they have more rights to stop and more rights to impede traffic, so to speak. So they played that up pretty well, that it's a public service vehicle. But I really think, our argument was, well, so what? You don't get to do dangerous things
right,
for no reason. And I really think what sort of made the case was these witnesses who said, look, we all told them, we all thought this was dangerous and called and told them it's dangerous. Once we were able to establish that they had that much notice, and in close calls, they were saying she should have been able to stop 100 feet away. Well, the one lady said, I stopped about 5 feet. I had this giant grill staring me in my front windshield and I was shaking. I was so scared, and she called and didn't get a hold of him. And she was so upset, she called back again, and then the other guy said, yeah, I don't know about stopping 100 feet away, but I was going to hit it if I hadn't gone around it. He said, that's,
yeah.
So,
well, and it's sort of this, idea of they're playing Russian roulette. I mean, 9 out of 10 people might miss it, but what about that 10th person?
Yeah. Well, and you're expecting people to be perfect in there, come over. I mean, they had her, perceiving it as soon as they saw the top of the truck, well, maybe she didn't see it right then, and then, trying to figure out, is it, one of the things we pointed out is just because you see it, you're saying she should have slammed on her brakes. Well, she doesn't know if it's moving, what
right.
if it's coming at her? She sees it rising as she's coming over the hill. If she slams on her brakes and stops in that lane and it doesn't move, it's going to cream her. So, she's got a lot to think about. And I think the jury understood that.
Yeah.
They, you mentioned earlier that they had tried to appeal it and you had cross appealed. It sounds like maybe it got resolved when it was on appeal. What were they saying was error in the case? If you remember,
there was one issue, and I can't remember if it was, there was an issue that and it wasn't a good issue at all. I mean, I wasn't terribly worried about it, but it seems like the judge had excluded some evidence, maybe, or it might have been about the statute, whether this, they should have got a different instruction on their duty with respect to being a public service speaker. There was some. I've never had a trial where they couldn't find some issue.
Right. Of course.
Yeah, exactly.
Always find something to try to put a little bit of fear into you, so you lower the verdict a little bit.
Of course. Well, I was looking at some press about the case back when it happened, and one of the quotes from one of the defense lawyers was about the verdict was that he was just really worried about what this verdict, did you see this, Steve? The message it would send to other businesses that
it's going to hurt business
that want to do business in Kentucky. And I just was like, really, dude? Come on,
maybe
man.
It'll tell them not to park over the
right. Yeah.
over a hill.
We got no problem with business. Just do it in a safe way. That's all we're asking.
Yeah, I mean, it's like it ruined a 17-year-old's life.
Yeah,
and you're immediately going to, you're worried the message this will send to people who might want to do business in Kentucky.
Yeah.
Anyway, I couldn't let that go without saying
no. Well, and Tyler, I'm interested to know. Did the case go through appeal, and I assume it got upheld, or did you get it resolved?
What it is there was about 11 million in insurance coverage, and so I thought we might get more than that. And I didn't think they were going to pay it, so we made a demand for it, and they didn't pay it. And it was interesting. The lawyer trying the case had the first $1 million layer of coverage. There was another lawyer who had the excess $10 million policy, and so my position was, hey, if you'll tell your company to tell them to pay it under Kentucky law, the liability for an excess verdict shifts from the business to the insurance company that could have got them out of the case, but decided to take their chances. So we made a demand for the 11. They didn't pay it. They gave us unlimited coverage. So when we got the verdict, we said, well, you guys are on the hook for it. And they were, and they knew it. So they came in, while it was on appeal, we had a day-long mediation and resolved the case, very favorably.
Good. No, that's fantastic. Did they, without disclosing anything as confidential, did they make anything that would have been considered a reasonable offer before trial?
Yes, it's interesting. We got fairly close. I think their last offer was maybe 5.5, and I turned it down, which it was a little nerve-wracking. I mean, they haven't had any large verdicts down there and that sort of thing. We had a trial a few years before with the federal government. It was in the Federal Tort Claims Act case. Mm-hmm. And I had been offered, like $400,000 in a very bad brain damage case. So we show up at trial, and they come in and offer $4 million. And then the next day it's $5 million. And then it was $6 million. And we said no. I think we were wanting more. Maybe 10 was our demand. And finally they came back and said, if you will, we got two offers for you. We'll do 6 cash, or we'll pay you 7, 4 cash, and $3 million in a reversionary trust that gets set up. And then, whatever's left over out of that goes back to the government. Client doesn't get to keep it. And I thought it was pretty underhanded. It's basically, but they said, but you get to figure your fee on $7 million, so it's like, we know this isn't better for the client, but you'll do this because you get to, so I went to the client and said, I want your permission to never speak to him again. And so he said, you have it. So I went back and said, I've got my client's permission to never speak to you again about settlement, and we're done. And so, we got 20.8 in that trial. And so a few years later, when they put 5.5 on the table, it was easier to turn down because I'd had that prior experience of having it work out. I will tell you, in that other trial, I had an insurance adjuster walk up to me who represented a different carrier. And he said, I heard you turned down 7. And this was during a break of the trial. And I said, yeah. He said, well, as far as I'm concerned, you've committed legal malpractice.
No, geez.
Right in the courtroom. So, I got that to think about for the next 2 weeks. Of
Yeah.
trial.
Right, yeah,
Verdict, but it turned out well. So when I was down there on that case, I was a little more comfortable, even though it was kind of an all or nothing. If the jury bought, hey, she should have stopped. She had, plenty of time to stop, which was the defense. Then, that we would have gotten 0. But that's the beauty of doing focus groups.
Right.
I was comfortable and confident that we were going to get a verdict after presenting it the second time.
That goes back to the question I asked earlier that I wasn't sure I understood. If they had found your client any percentage at fault, is it a contributory negligence, or is it just a percentage set off?
It's a percent. It's comparative negligence.
Okay.
So,
all right.
yeah, I'm sorry. We have pure comparative. So if they
okay.
find her 10% at fault, she gets to collect 90% of the award.
Or I mean, the reverse of that is if they find her 80% at fault, she still gets 20%. Is that right?
Yeah, she's going to get 20% and not get the other 80%.
Right. Okay. And then the other thing that I'm sure helps you, I don't know if you still have it, but back in 2002, I'm sure was great, was when you're negotiating a case, the interest on your judgments is 12%, which is that's a pretty healthy percentage.
Yes, our legislature changed that a few years ago, unfortunately, because it did help get cases resolved. It got rid of a lot of frivolous appeals.
Yeah, they did the same thing to us here in Georgia. We used to have 12% years ago, and that went away a long time ago.
Yeah, it was. A lot of times we were like, "Go ahead and appeal."
Yeah,
that's right. Exactly. Well, Tyler, this has just been a great conversation, and thank you so much for telling us about the Houchin versus Republic Services of Kentucky, doing business as Monarch Environmental, and Jackie Jones verdict that resulted in a $27,335,667.87 verdict. And I just wanted to ask you, Tyler, is there anything else that we haven't had a chance to tell our listeners about that you want to make sure they know about that case?
No, I think we've kind of hit the high points, and glad to spend time with you. Be sure and call me if you get up to Louisville.
Yeah, no, absolutely. Absolutely. It's a great city, and I look forward to being up there in a few weeks. So, but Tyler, thank you so much for your time, and just wanted to we really appreciate you coming on.
All right. Thank you.
Okay.
Glad
Thank you.